This is a statement for workman's comp in Stockton, California, Judge Grill's Court. My name is Julio Zamora. I live at 1385 El Camino Way, Los Banos, California, 93635. My employer is Safeway Tracy Distribution Center in Tracy, California, 1-800-388-2125. This statement is regarding disability. I received a notice of offer of work on December 1st, 2010. I went to work on December 3rd, 2010. On the 5th day of work, on December 7th, 2010, I was flat out sent home. And it's a union shop. And I should also note that they refused to honor the notice of offer of work on December 7th, 2010 because I received the notice of offer of work on December 1st, 2010. And that Safeway and Distribution Center in Tracy, California is a union shop. The union attorney, Local 439 in Stockton, California, refused me arbitration. And the attorney said he understands that we have disability issues, but he is not going to take this case to arbitration. And that if I wish to do so, I can pursue it under workman's comp in Stockton, California. Workman's comp in Stockton, California. Will I choose to do so? So that's why I'm making the statement. Workman's comp, Judge Grill, that it's okay for me to pursue this disability case that the union refuses to hear or take to arbitration. So that he said that I can pursue it, and that's what I'm doing right now. And it's all about my disability issues on my injury on 3/21/2009, and the fact that I received a notice of offer of work that was completely denied more than on 2 occasions, and the fact that I have 2 children and the university that I'm supporting, and also the fact that I was born on September 7th, 1940. I'm 72 years old. And I hope he considers that, and the fact that down in the restatement I'm making, that I hope he considers putting me back to work and with automatic retirement on my birthday in 2013. And that personnel to be informed that I will be automatically retired, whether I like it or not, on September 7, 2013. And that they're to have a letter stating that I'm retired from Safeway because of my disability, if it's at all possible. And I'm hoping the judge allows me that consideration due to the fact that I have a notice of offer of work that I received on December 1st, 2010. So I hope he considers this in the interest of justice. And here we go. Okay, and here we go. One more time. Today is Wednesday, January 9, 2013. Wednesday, January 9th, 2013. This is Julio Zamora, 1385 El Camino Way, Los Banos, California, 93635. I was employed at Safeway in 2002. I got almost 10 years working at Safeway. It's also a union shop, local Teamsters 439, Stockton, California. This is a statement for Judge Grill's Court, workman's compensation. It's a union shop. The union took the position when I requested arbitration that you guys arbitration, and that I could pursue it under workman's compensation. I can pursue it under workman's compensation due to the fact that they were aware that I had some disability issues. And the fact is that I wasn't notified on anything regarding union contractual procedures. I was I was notified by phone there was a panel hearing in 2011. I did not receive any registered mail concerning grievances or anything else for that matter by registered mail. I was informed by a phone call in 2011 that there was a panel hearing, and it was put in a bid when I mentioned to them that I have a hearing impairment, severe profound hearing impairment. To Mr. Nightwater, they put the meeting in a bid, and that was the end of that. Requested arbitration, like I said before, and it was denied and referred to workman's comp. I can do that if I wish to do so, and which I did. So this is a statement for Judge Bill's court that I hope he considers it. And also I'd like to mention the fact that I was not fired on December 7th, 2010. I was just flat out sent home on December 7th, 2010. So going from there, I'd like to know one thing. On 3/21/2009, I was limping and they sent me to the company doctor. On 3/21/2009, I seen a Nancy Perdillo, who was the first one to see me, and she gave me drug and alcohol tests. And she talked to somebody on the phone. Who it was exactly, I don't know. But she signed it, and then on the other copy, I signed this copy, drug and alcohol test, drug screening results. And then I have another one here who was, that I guess I took at 3/22/09, provider signature, I can't read it. Okay? And she said that it was a sprain. So on the next day, on the follow-up, I guess, it says left leg side sprain, knee sprain, and cannot drive, no swelling, no this, no that, and no driving. And that's what he said, initials OE, whatever that is. Okay, and did he give me any prescriptions? Rapid drug screen was done. EBTA required, done. Anyway, that was it. That was on 3/22. And this check remained off work. And it says I can return to work right through the 8 hours a day on 3/22/2009. Okay, so my next appointment was 3/30/09. Okay, that's the document that I have. Accident and treatment activity report. Okay, now, going further. Okay, at 3/30/2009, they said I was unable to return to work. I saw his last name was ABAPANDMPH, whatever that means. And I initialed the report, and it said unable to return to work, and that's all it says. Next office visit 1 week, Monday, April 6th at 9 o'clock in the morning in 2009. And it authorizes physical therapy in Los Angeles, which I was unable to do because I was in such great pain I couldn't bend backwards. Okay, so we know that much. Now, I ended up in the Los Angeles Hospital on 4/5/2009. 4/5/2009. The date of injury was 3/21/2009. Okay? So, that's the day I was admitted on 4/5/2009 to the hospital. And they made out an occupational report. Okay? And it says here that I went in for left leg pain and I came out with low back. They took an MRI. Low back pain, radiology, whatever. They took an MRI. That's from the Los Angeles Memorial Hospital, okay? And date of amendments was 4/5. I was out of there on the next day, about 5 or 6 in the morning, when I took an MRI. Now, I'd like to note the fact that I had to go to Tracy, the company doctor, to see Dr. Hubby, because they had made an appointment for me. So this was done on 4/5. March 6th, I got out of the hospital. I had to see her on 4/6. Okay? So, and unable to return to work on 4/6, I had to see Dr. Hubby, and that's the Memorial Hospital kept me off work until 4/6. Now, okay, so, we know that I was in a hospital on 4/6, and we know that I went in there for left leg pain. Okay, and we know that the governor or the prior, whoever that doctor is, said I had no swelling, no nothing, and I was on light duty. Okay, I got the wrong diagnosis on 3/21/2009. I got the wrong diagnosis again on 3/22/2009. I ended up in a hospital on 4/5/2009. I was out of the hospital on 4/6/2009 around 6 or 7 in the morning, and I proceeded to see Dr. Hubby, I believe it is. Let me see what it says here. Yeah, I saw Dr. Hubby, I guess, because here there's a letter which is a response to Dr. Hubby. Thank you for your request. This is from Safeway to Dr. Hubby. Thank you for your request dated 4/8/2009 for a referral to a neurosurgeon with employee's low back. We respectfully object to your request at this time, as the accepted body part for the above captured claim is left thigh and left knee. It is noted that when you initially evaluated Mr. Zamora, he was not suffering any symptoms to his low back. Please advise your opinion of employee's current symptoms to his low back and related to the industrial injury of 3/21/2009. Did the employee suffer any new injuries either on industrial or non-industrial basis? I should like to note that they sent the letter or asked the question to the wrong person when it should have been sent to Nancy Perdillo. And this letter was dated April 14, 2009, and they were referring to 4/8/2009. I remind you that the fact that I got out of the hospital on 4/6/2009, and I gave Dr. Hubby an MRI at 4/6/2009, which stated that I went in with low back and came out. I went in with left leg pain, okay, and came out with low back, okay, and then the rest is history, I suppose. They had me on light duty, which was unable to do, okay. And then I seen this lady, what's her name? She puts you on light duty, and her name is Michelle Ortiz, okay? And she put me on the health and safety room, light duty, because I've been on light duty since 3/21/2009. And it states, no lifting, 10 pounds, no pushing, pulling, walking, going up and down stairs, and other, okay? And the next appointment was 4/15/09, and this was signed on 4/8/09. 4/8/09. Okay? And they had me on light duty, and they had me all doing this stuff. Okay, right? And then further, I'd like to state that that was a continuous thing with them until 4/17/09. I went to the company doctor stating I couldn't take this light duty anymore. For the fact that I was in a lot of pain, and the swelling was getting bigger and bigger, and I just couldn't take any more light duty. And I live in Los Angeles, it's a long way to go. Okay? So, I mean, there's 400 employees there. They live all over the place. Bakersfield, Sacramento. I don't know what they do if they have to go to an emergency, but I ended up in emergency, and I got a phone call from Miss Esperanza, insurance company in Arizona. She called me and said that I didn't have, well, she mentioned, I'm not sure. I am sure that she mentioned the fact that I'm not allowed to go to the hospital. That's what I received in my mind when she talked to me. Said, well, why did you go to Los Angeles Hospital? I said it was an
me. I said I couldn't make it to Tracy. Anyway, she got upset. So I'd like to make that statement, but just to consider. Okay, so now we know that the insurance company got upset because I ended up in the hospital. And then they gave me the wrong diagnosis and they kept me on light duty. And I went back there and I went to see, I guess Bartel, whatever, or Pullman. I don't think his name this is. Okay, anyway, it was on 417. And the name of the person I saw was Patel, just at 417. Okay, I got his report here, 4/17/2009. Current work status. Unable to return to work. Severe back pain, medical problems until next visit. I am not sure this is an industrial condition. Next office visit 1 week. JP only 4/24/2009 at 10 o'clock. And then patient has serious medical problems and he needs complete workup, including neurological consultation. And then was signed by Dr. Patel. And I signed the work status report, Julio Zamora. I have read and obtained a copy of this work status report. Remind you, FBI 14078974481. And this is the only copy that I got. I never received a PR2 report, and I don't remember it. And I don't remember signing it. Okay? Now, I have a copy of the PR2 report. And I should like to note, it says, vitals taken on 4/17/2009 at 12 in the morning. Okay, and he says, I think all his problems are non-industrial conditions. I think all his problems are non-industrial conditions. I advise Mr. Zamora to get medical attention from private basis and figure out what is his problem on non-industrial basis conditions and not caused by any injury at his work. He will be on TTD on private basis. TTD, I don't know. I was on disability anyway. I filed with the unemployment office. And also, this exam was done on 4/17/2009. Okay? And I'd like to also note that it says the box is checked, return to full duty on 4/17/2009 with no limitations or restrictions. And then he checked the other box. RTW as per week, status, paper signed by patient and doctor, and it is attached with this REG. Primary treating physician, original signature do not stamp, date of exam 4/17/2009. And I'd like to note, I looked at the second page of this paper. It says, I declare under penalty of forgery that this report is true and correct to the best of my knowledge, and that I have not vindicated or some, I did not violate labor code 1393 point, okay, and it says signature, executed at Tracy San Joaquin County, California, dated 4/17/2009, name, Bartel MD, address 644 West Grove Street, Tracy, California. Okay, 209-832-8984, and that's it, okay? There's no other signature on here. My name is not on this PR2 report. I'd just like to note it for the record that my name is not on this PR2 report, and it says down here below, it says signed by patient and doctor. Then it's attached with this REG, primary treating physician. So I'd like the court to realize and to know the fact that I got it wrong. Diagnosed on 3/21/2009, and they had me on light duty, and on top of that, he's indicating that I signed this. And on the second REG with a page 2, okay, 28, 2009. SanitaryService.com Safeway Protected PDF 3031107-3JPG. I guess the third page was the one that I just read to you. Current status report. That's the one I did sign. But I didn't sign the PR2 report, so I'd like to know that for the record, and I have a copy if anybody's got any questions about it. Okay? So that's that on the PR2 report, and we know that I ended up in the hospital and I gave you the wrong diagnosis. And there's no doubt about it. That's the absolute truth, and I have a report of occupational report made up of the wrong time. I was hospital saying I went in with left leg pain, came out with low back. Now, we're going to get into the fact that I was denied benefits, everything. They took me off with disability. They just denied me everything. Medical treatment, this and that. Okay, on 4/17 or 4/18, I received a letter of denial from Lucia Esperanza, who was handling my work for comp case, and I received a letter on November 11, 2009. And it says, after careful consideration of all available information, we are partially denying all liability for your claim of injury to injury to the back. The medical evidence from Dr. Patel dated 4/17/2009. Now we know I didn't sign that report. Your lumbar MRI findings reveal spinal stenosis. And they're talking about the MRI that I presented to Dr. Huff, which is a pre-existing condition and recommends medical treatment on a non-industrial basis. If you disagree with this decision, you have 1 year from the date of entry to file an application before Workmen's Compensation Appeals Board. Okay, well, we won't go into that. The fact is, I hired an attorney at 4/17, Adam Stewart, and that was that, okay? So, and this is a part of the amount of workmen's compensation benefits, and later on I had a complete denial of everything. All the way up to 2012. They denied me everything. They just didn't do anything. Okay, I should also let you know, I filed an application for hearing impairment on 4/13/2009. And I also like to note that the cartel's office, they give me a hearing test every 2 years. And I also had a hearing test from Dr. Yes in Los Angeles, California, who took my treating physician, my doctor for 20 years. They denied me the right to have Dr. Yes as my treating physician. I stand to be corrected on that, but this is 2013 and they still haven't approved it. So, long story short, I filed for a hearing impairment on 4/13/2009, and I never got a hearing aid or listening device or anything else for that matter, not even from the union, who put my panel hearing in the bid and suggested the fact that if I need hearing aids, they would pursue it. They would discuss it with the company. And it was never done, and I never heard a word from them, and that was in 2011. And I was sent home on December 7, 2010. Okay? Now on 9/14/2011, I went to take the hearing test in Charlotte, California. Okay, and it states that I have a severe, profound hearing impairment. And I also had a settlement conference that the Fed Bill ordered the 2 attorneys to get me a legal document for severe hearing impairment. And I presented the copy that I had, that I needed accommodation needed for trial for hearing aids to be purchased at Kathy Tova Tower Center for Better Hearing, 1801 Colorado Avenue, Suite 150, Charlotte, California, 95382, 209-216-3300. And I need a court order to get hearing aids because I bought the last pair of hearing aids and they don't work. They're broken. on from there. Now, on 4/17/2009, I filed for disability with the UEDD, Unemployment Office. And they sent me a letter that I was a notice that Safeway was, I got a notice that Safeway was in conflict of liability. Mailing date was 6/16, claim effective date was 4/17. Okay? And it says you haven't provided information which indicates that you may be entitled to workers' compensation benefits. However, since your entitlement to workers' compensation cannot be determined by your employer, however, since your entitlement to workers' compensation cannot be determined by your employer. And I just wanted to read that notation. At this time. So we know that they have no right deciding anything, and they gave me the wrong diagnosis. I have to keep bringing that up to remind the court, because they denied me everything, hearing aid, hearing accommodations on hearings, and just totally ignored me. Okay, so we got through that. Then, in 2009, they just taking me off work, putting me on. I had a full release to go to work. They ignored it. They didn't put me to work. They kept me off. They didn't pay me back pay, pension, benefits, RSVP, etc. Nothing. I didn't make very much money that year. In fact, I got a letter that said they sent me one check for $10,000 minus 15% of this or that, and that's what I got for the year. $10,000, and I have 2 children at the university, and I need 1 more year of work for her to get her BA degree in biology chemist. So going on for that, on December 7, 2010, I received December 1st, 2010, I received a notice of offer of work. A notice of offer of work. Okay, and it was sent to me by Lucia and Ferranza in Safeway Insurance Company in Arizona. And the QME report was taken from Ronald Fornoff, MD. Okay? And it says here that, it's off the paper, okay. I got the notice of offer of work, and it says here that it was sent by Lucia and Ferranza. Okay, my employer was Safeway, the claim number was 25009-25228. QME report. Birthday 9740. Injury date 3/21/2009. Date you're eligible to return to work is 10/13/2010. But that I was already working in the year of 2010, so, but I didn't have this notice of offer of work. I didn't receive it yet. Okay? So I go on to say that I also applied for a change in attorneys. I had to go to Central Valley Injured Workers Legal Clinic because Adam Stewart did not enforce the notice of offer of work. And I'm not going to elaborate on that. And the fact that there was no legal document presented to the Judgeville court regarding severe profound hearing impairment. Judgeville was not made aware of that I had a hearing impairment and I couldn't hear. So no listening device or anything else was done to help me when I went to court, in Judgeville court. So he had to put the case off calendar because Adam Stewart did not put the legal documents in his hand concerning severe, profound hearing impairment. Okay, back to the notice of offer of work. Okay, on page, I guess it's page 3, it says that the employee must accept, reject, or object to this offer for regular work and return this form to the employer or claim administrator listed on the form within 20 calendar days of the receipt of this offer, or it will be deemed that the employee has accepted the offer and has waived the right to object to the location and shift It's asking me for the day shift if I want. It says here, this position is for a different shift that you pre-injury position. This shift time is 10 o'clock in the morning to 12 midnight. Eureka run, 14 hours a day. Okay, overnight. And I also wrote down seniority to be intact. Hired in 2002, so I've got about 200 employees underneath me. Okay? And I should also know that they kept sending me copies of this notice of offer of work, sign it, send it back. And each one has a different page. I don't know what's going on, but they all mean the same thing. Okay? So this notice is not. The other notice was from Esperanza in Arizona. This notice was from Florida, MOLTES, Safeway Private Insurance in Arizona, California. Her phone number is 209-833-4805. Okay? And she received a copy of this by registered mail. Okay? And it says this position provides wages for $1,006.56, okay? And then it goes on to say, the wages and compensation paid to you at the time of your injury is equivalent or to more. And then it goes on to say, this position is expected to last for a total of at least 12 months of work. If this position does not last for a total of at least 12 months of work, you may be entitled to an increase in your permanent disability benefit payment. And I'm taking that to mean that if there's work available, they'll pay me the difference if I'm not working. Well, there's work available. Okay, at 10 o'clock in the morning, Eureka run, and I have almost 200 drivers underneath me. And furthermore, I should note under the contract that anybody that works below me in seniority, I get paid for that day. And it's a 24-hour operation, 7 days a week. So if anybody works in those 7 days underneath me in seniority while I'm waiting at home to be called to work or register mail, which was never done for whatever reason, I should get paid for that day. Okay? Because of the fact that they didn't follow contractual procedures and they never responded in 10, 20, or 30 days. No registered mail, no nothing. And so no panel hearing, and I suggested arbitration, and they said I could pursue it at workman's comp, and that's what I'm doing. So, okay, so this is a legal document. This is a legal document, and they didn't complete their agreement. Okay? Because I checked the box that I said on here, it says offer of regular work at same location as shift, and I checked, I accept this offer of regular work. Okay? I received this offer on 12/1/2010. On 12/3/2010, I went to work. On 12/7/2010, they just flat out sent me home. Just sent me home. Nothing in writing why, what, or anything else. I was just sent home. Okay? And when they did that, I had a lifetime medical that I bought. And I lost that, and everything else. So, they didn't pay me no money every week or every 2 weeks. The insurance company didn't do anything. As well as Safeway didn't put me to work at my 10 o'clock in the morning shift, Eureka run, in which I checked the box and said, I accept this offer of regular work. Okay, and above it, it says offer of regular work at same location and or shift. And it was dated 12/1/2010. Okay? And I also checked another box, and it says offer regular work at a different location and or shift. And I checked the box that says I accept the offer and waive my right to object to the job for location or shift, not being within a reasonable commuting distance from the residence where I live at the time of my injury. So this is a legal document, okay? And it's deemed accepted if it's not within 20 days. So it's enforced. They took the money, but they didn't let me work. They just flat out sent me home on December 7th, 2010. Okay, so that's the thing about the notice of offer of work, that I've been refused to go to work at least 3 or 4 times. And my attorney received a letter from them in 2012, okay, regarding the notice of offer of work, and they give me another offer. They've been giving me offers and everything else, but then when I get to see my Sadler or the union, they go, I don't know anything about it. And this has been going on since December 7th, 2010. They don't know anything about anything. They're in a state of denial. They don't know anything. But then I have documents, and I have a document from our attorney that says to report to work. And I was denied by Mike Sadler. So if you were to ask him, he would say, the first I heard about it. So that's where that's at. So they refused to put me to work according to the notice of offer of work, which they didn't honor because I'm not in the 10 o'clock shift Eureka run according to the agreement with Workers' Comp. Okay, now the PR2 report. I have the QME report here, which I'd like to read a few things because it's very, very important. My life is on the line here, okay? And I need to be returned to work so I don't lose my lifetime medical insurance for my family and my children, which will protect them for up until they're 26 years old. So going forward with this is the QME report. Pre-injury capacity loss. Examinee can't perform most activities of daily living. He has some discomfort in the back with prolonged sitting, standing, walking, and driving his truck. Examinee can return to his usual and customary duties. And I was sent home on 12/7/2010. And I was also on FMLA, okay? And I have seniority. There's no reason why they can't work me, okay? And then I'm going to read this other part. Now, we know about that one, okay? There's no work restrictions. There's no work restrictions. It says work restrictions, none. Okay, work restrictions, none. Okay, that's like having a full duty release to go to work and they refuse to put me to work. Okay, now, we're going to go over here and prognosis, okay? Examining mechanism of industrial injury could not have caused multiple alleged problems noted in the cervical and lumbar spine and left knee. I'm assuming that the QME report is reflecting the report of the PR2 report for Dr. Patel. Okay? This leaves a reasonable person to conclude that the pre-existing arthritis in the cervical and lumbar spine as well as the left knee had contributed to the examinee's clinical situation. At this time, I would appropriate 30% of CAUS-ATION to non-industrial cause and 70% to the work injury. I'd like to note that for the court. And no changes anticipated, prognosis. So this can't be amended because he said no changes anticipated. He doesn't intend to make an amendment, in other words. Okay? So anyway, that's it. They didn't honor the notice of offer of work that I received on December 1st, 2010. I went to work December 3rd, 2010, and December 7th, 2010, they flat out just sent me home. Just flat out. And I haven't been paid every week or every other week. I get paid once a year. The last check I got, the first one was $10,000, the last one I got was $3,000 for the year. And they've been taking out 15%. And they denied me all medical benefits, disability payment, and everything else. They keep sending me they're going to do this, they're going to do that, and they don't do it. And like I said, they don't do it. But they did send stating that the company offered me work to my attorney and to me in 2012. They said there's work available. They're offering me to go back to with all back pay and benefits and RSVP to be restored, and to be paid 14 hours a day, 7 days a week. According to the contract, anybody that works below me, I get paid for that day. It's a 24-hour operation, 7 days a week. And I also asked him that I be automatically retired on my birthday in 2013. Automatic retirement, whether I like it or not, and personnel department to be informed so that I can have a letter that I retired from Safeway on September 7th, 2013. That's my birthday. I'll be 73 years old. So I'm asking a court order for that due to the fact that in 2009, they never paid me back pay, benefits, or anything else. They didn't. I had a full release to go to work, and then all of the issues were related to disability worker comp issues. And the union did not do anything about it, and they didn't help me get a hearing aid or a listening device at any time, any place, anywhere. So I could pursue this under the union attorney who gave me a letter stating I could pursue this under workman's comp because I have disability issues. So workman's comp can decide this for me, and I would appreciate it if Judge Bill considers this and return me to work. Now, I just have one more thing, and we'll be done with this. Where is this? Oh, well, I just have one more thing to say, okay? I invoke double standards. Life is not.
Okay, today is Friday, January 11, 2013. And the fact is I went and had a hearing test, a legal document ordered by the court. The last time I had a workman's comp hearing, he canceled it because I didn't have an interpreter or a proper hearing device, and I gave him a document showing that I was deaf, but it wasn't a legal document. So yesterday I went and took the examination, and there's no doubt that I'm deaf. And the damage is already done. There's nothing that can be done about it. In fact, it's getting worse. It's ringing off and on, according to the doctor. And he suggested I should wear earplugs. But I can't wear earplugs if I'm driving my car, right? Until I get some hearing aids. The hearing aids I got, they work and they don't work, and they're really old. They're just really old hearing aids. They'll work for the meantime, off and on, but that's all I need is I barely passed the test, and so I can work. There's no problem about going to work. I have a valid license and everything, so there's no reason why they can't put me to work. And there hasn't been. Okay. So anyway, it would take 2 or 3 weeks for the report to come in, but the fact is I'm deaf. That's the bottom line. And that's not the reason why I was sent home on December 7th, 2010. It wasn't because I was deaf. It was because I received a notice of offer of work on December 1st, 2010. According to the QME report, I could do my job, in other words, okay? Anyway, they sent me home flat out on December 7th, 2010. And me being deaf then has nothing to do with them flat out sending me home. At least I don't think so. I won't know until we go to court. And I should mention the fact that I had a panel hearing with Safeway in 2011. A nice longer. I had a panel hearing, and they stopped the panel hearing. And he took me to the back room, and he wanted to know why I didn't say anything. And I told him that I have a hearing impairment. I have a severe hearing impairment, and he said, well, that's the first I heard of that, but that's not true. My wife knows that I told him that I have a hard time hearing, and that I don't recall exactly, but I'm sure that I mentioned the fact that I had a hearing problem since 2009 or before. But in any event, I told him and the two shop stewards that were present that I had a hearing problem and this and that, and it was a big issue. I don't know what to say. And then I was talking to Chuck Stewart, and I told him, "Are you an authority on profound hearing impairment?" And he was just stunned. He didn't say anything. So the panel hearing was in abyss, and they just flat out sent me home. They never sent me any registered mail in 2010 about my situation, and I called them before Christmas, and Safeway never responded in 10, 20, or 30 days. Nothing. Okay? And I told him I had a hearing problem. Mr. Nicewanger, he said he's going to talk to Safeway about it, whatever. He's going to pursue it, right? Well, they sent me home, and I never heard a thing from them. That was the end of it. And then, and so now I'm bringing it up now because the judge in Workman's Comp said get a legal document. Now I've got 2 documents that say I was deaf. 2 documents. Okay? And so anyway, the union attorney sent me a letter that they're going to deny me arbitration, and I could just pursue it under Workman's Comp because their understanding is I have disability issues. Disability issues, and they're not going to go to arbitration. And if I want to pursue it, I can do it under Workman's Comp. Now, they didn't finish the panel hearing, and they just dumped me right out, and they didn't follow contractual procedures, and then this guy here falsified my documents and everything else, and didn't make me aware like he's supposed to, and the fact that I was deaf, and I asked for a shop steward to be present or somebody to explain to me what the heck's going on, and nothing was done. And there was a lot of drivers in the driver's room. They even asked me, they go, "What's going on? Why is this guy throwing his hands up in the air? And now I got Zamora and all this stuff." And I didn't understand a damn thing he was saying. I had no idea. I told him, "I don't know what you're talking about. Man, what's going on?" But the fact is, he didn't make me aware that he altered my logs or changed the time of my logs according to the data machine in the driver's room, which doesn't have a time code. It doesn't do anything. I mean, we're already on duty, but he's saying I wasn't on duty, but the Department of Transportation, the federal government says I was. So who's correct? I have no idea. I just followed DOT according to the contract and according to company policy. And that's what I did. And what he was yelling about, I don't know. Okay, I don't know what he was talking about. The drivers asked me if I was going to get paid for that day. And they asked me what was going on because I was sitting there all day. And I told them, I don't know. I haven't the slightest idea. And then the terminal manager comes over and whispers something to me like I'm supposed to know what he's saying. And I didn't understand one word of what he was saying, and he jumped in his car and he took off the property of Safeway. He just flat out took off. He just whispered it and just took off, whatever he said. So, that's it. I was deaf. I received a notice of offer of work on December 1st, which they held it up since October. Agreement made with Workman's Comp to work me for 1 year. We don't have to go through all that. But the point is, they need to return me to work because of the notice of offer of work guaranteeing me 1 year of work. Okay, but now we find out that I'm legally deaf and I have a legal document, so that puts the union in a bad position. I would think so. I don't know for sure until I go to an attorney because I have a document from the union attorney stating the fact that we're not going to hear this case in arbitration, okay, because we can't win this case. That's what he said, okay? And that was it. And he sent me a letter saying I was fired on December 16, 2010, but he didn't mention a word about it being denied on December 17, 2010. And he didn't mention a thing about the panel hearing that I mentioned that I had a hearing impairment. Nicewanger. The attorney didn't say one darn word about that, but he did say that they were aware of the disability issues, and I sent him documents that I had a hearing impairment. I did everything I could. I responded in 10 days, and everything else, but that wasn't acceptable. So I have a legal document. The union is wrong, and Mr. Nicelonger, he better get out of that bed of his with Safeway and get me back to work. Because I have a legal document that says I was deaf, and I didn't understand what was going on at the panel hearing, and I didn't know what was going on when the dispatcher had me escorted off the property or whatever it is, and he falsified my documents. There's no doubt about it. Okay? So I'm innocent. I'm innocent. There's no doubt about it. I got legal documents now. And that was ordered by the court in workman's comp. So, I don't know what the union's gonna do, but I know Mr. Nicelonger better file a grievance and everything and complete that panel hearing, because, Safeway's wrong. They're wrong. They're guilty. They need to be returned to work like 1,500 other Teamsters, because they didn't respond in 10 days, 20 days, or 30 days. And then James Williams, the terminal manager, he knows this. And why isn't he putting me back to work? I don't know. Is it because I'm deaf? Or what is it? Because he didn't honor the notice of offer of work, you know? And then the dispatcher took my time card or my log sheet or trip sheet or whatever, and everything and threw it in the garbage because I didn't get paid for that day. And he's working and I'm not. And he's not deaf. He falsified my laws. He's not supposed to do that. Now, he broke the law. That's a serious thing. And why is he working and I'm not? And I'm the one with the permanent disability according to the QME report. And I can do my customary duties. And I have a permanent disability. There's no reason why I can't work. I didn't do anything wrong. So, I don't know how I'm going to, I don't dare call Nicelonger because I don't know what, you know, I think that's just a lost cause. You know, I don't know. I'm going to put this on the internet, and I don't know what's going to happen after that. You know, maybe he'll hear about it. I hope he does. And then maybe he'll go ahead and file a grievance or whatever that the union attorney decides to do, but they're all wrong. They got all their facts wrong. I thought they were supposed to have an investigation. What kind of investigation is that? They didn't prove any evidence. They didn't do nothing. And they violated the labor code. And the fact that I got a legal document, that's not good. They definitely violated the labor code. So, and they violated contractual procedure, and they violated workman's comp rules and regulations. Now, I'm not the one to decide whether they did all of that. It's up to the judge. But I'm thinking that they did. So we won't know until we get to court. And the fact that Legal Clinic will get a copy of that. That I'm deaf, and plus they have the notice of for work that they're looking into. That's what they said, but the attorney sent me to work, and they, Mr. Mike Sadler, he just said, I don't know anything about it. And the union said, well, I don't know. At first I heard of it. Every time I turn around, I don't know anything about it. They're in a state of denial. It's a waste of time for me. They'll be going there and calling them and say, hey, you need to put me to work and this and that. Just a waste of time. They took my lifetime medical away. I got my daughter needs one more year of college, and oh, Jesus Christ, man. You know, so I hope the workman's comp judge, gives me that automatic retirement on my birthday this year. Automatic retirement with a letter saying that I'm retired from Safeway and that I have a permanent disability. Because I can't work there any longer after all this. Because they need to pay me from December 7, 2010, back pay and benefits 14 hours a day. Eureka run, which is that's what I asked for on the notice of offer of work. That's what I asked for. I didn't, my 10 o'clock start. I never worked one day on the 10 o'clock start. And they took 15% away. And now I'm deaf. And they haven't paid me disability payments every week or every 2 weeks. So what kind of outcome of that is, I don't know. But they need to put me back to work so I get my lifetime medical. There's no reason for them to keep me off work. Not one. Not one. Nothing. And the guy that falsified my documents, I don't know why he's working and I'm not. Okay, because I didn't do anything wrong. So if he should work, I should work. And the 1,500 other Teamsters are put back to work because they don't file a grievance or do whatever within 10, 20, or 30 days. They're violating step 1 and step 2, null and void final binding. So I guess the union attorney better clean this up and look into it, because there's no doubt if the union doesn't get me back to work, I'm going to go to an attorney. I have to. And I don't want to. That's not what this is about. It's about 2 children going to the university. That's what this is all about. It's not about trying to work longer because I'm going to be 73 years old this year. It's got nothing to do with that. Nothing. It's about getting 2 kids through the university. That's it. So they have a chance in life, and I can get that under my belt, and I'm going to feel good about it. That I did all I could so that my children will have a chance in life. Yeah, I'm going to feel good about that. You know what, to be honest with you, I'd love to retire, but I have responsibilities. I have responsibilities to my family and to my children and to myself. You know, I mean, they're children. They need a chance. For Christ's sake, this isn't about trying to make more money. I'm happy with what little I have with my Social Security and everything. I don't know what they're saying about me. I'm rambling on because I have no idea what they're saying. I know they're attacking my credibility, and I don't care. They can attack it all they want. It's not true. But hurting my family and me like this is not right. It's wrong. You know, and I gotta get my son. Jesus Christ, he needs help. And my daughter needs that last year, so I'm fighting back, okay? And I know, like Adam Stewart said, you guys are stubborn. No, I'm not stubborn. I'm just standing up for my rights. I'm standing up for my rights. Do I have any rights? I'm innocent. I'm innocent. Do I have any right to stand up for my rights if I'm innocent? Or it's just already decided and that's the end of it? No, that's not the end of it. You don't just go hang somebody or electrocute somebody because they're innocent. They got a right to speak up. They got a right to stand up and prove that they're innocent. Well, I proved I'm innocent. So why am I back to work? And because I know they got investigators out there, and they know I'm innocent. No matter how they look at this thing or flip it around or try to twist it, it's just not going to matter because I'm innocent. I got legal documents that show I'm innocent. I should be working. And I know they don't want to pay that back pay, but they're going to have to pay it 14 hours a day, 7 days a week. That's right, because anybody that works underneath me, according to the contract, has to pay me for that day. And now they put themselves in that position. The dispatcher screwed up. James Woods, the transportation manager, screwed up. And Mike Sadler screwed up. They all screwed up, and the union. So they need to get me back to work. Okay? And that's how I feel. And it's really hard right now. And it's not good. It's not good. So, in the name of Jesus Christ, man, let justice be done. A double standard is the application of different sets of principles for familiar situations or to different people in the same situation. A double standard may take the form of an instance in which certain concepts, often, for example, a word, phrase, social norm, or rule, are perceived as acceptable to be applied by one group of people, but are considered unacceptable, taboo, when applied by another group. The concept of double standard has long been applied, as early as 1872, to different moral structures on men versus women. A double standard, thus, can be described as a sort of biased, morality unfair suspension toward a certain group of the principle that all are equal in their freedoms. Such double standards are seen as unjustified because they violate a basic maxim of modern legal jurisprudence that all parties should stand equal before the law. Double standard also violates the principle of justice, known as impartiality, which is based on the assumption that the same standard should be applied to all people without regard to subjective bias or favoritism based on social, class, rank, ethnicity, gender, religion, sexual orientation, age, or other distinctions. A double standard violates this principle by holding different people accountable according to different standards. The phrase, "life is not fair," may be invoked in order to mollify concerns over double standards. There is a distinction to be made between double standards and hypocrisy, which implies the stated or presumed acceptance of a single standard a person claims to hold himself or herself accountable to, but which in practice may be disregarded. Being hypocritical to the double standard is then a positive example of hypocrisy as well. Though the term double standard is of relatively recent origins, the concept expressed by it has existed in various cultures from far earlier times. For example, Jewish tradition has interpreted in this light the biblical injunction in Deuteronomy 25:13-15. Do not have two differing measures in your house, one large, one small. Do not have two differing weights in your bag, one heavy, one light. You must have accurate and honest weights and measures, so that you may live long in the land of the Lord, your God, is giving you. The modern Hebrew term for double standard is derived from this biblical verse, Ipia v. Ipia, literally, two differing measures. In the interest of justice, I hope that Judge Will considers this, so that let justice be done in the interest of justice.
I, Julio Zamora, invoke double standards. Life is not fair.